You're on Legal AF, and it is unprecedented. Not that my co-anchor Dina Dahl is with me. That is expected. But all the things we're going to talk about today at the intersection of law, politics, and the United States Supreme Court, things that are there, things that they are planning to do, things that they've already done the next term. And we're starting to accumulate now, Dina, the important cases that are going to be heard at the first term. I think next week we'll add a special section on as a little bit of a cliffhanger of the cases that they've already accepted and what we think the first term will shape up to look like. And I think we're starting to get to that point now as they finalize in August and September. Maybe we'll do a post-Labor Day. Let's do a post-Labor Day show devoted to the upcoming term. How's that sound?
That sounds great.
Sounds right? Okay. So the three things that you and I thought were very, very interesting for our audience to focus on this week was one, the Voting Rights Act and the fact that it's not only on life support, something that was passed in 1965, literally in the wake of the Selma Bridge, the Edmund Pettus Bridge attacks of Black civil rights leaders, young civil rights leaders, John Lewis among them, who was almost killed by a sheriff's baton, a cop's baton. And that led Lyndon Johnson to ultimately get the Voting Rights Act passed. It used to have two major components to it that would protect voting rights of people that were not white. One was Section 5 and one was Section 2. Section 5 was, we don't trust southern states to run their own elections because when left to their own devices, they would find a way to screw Black and brown people. They literacy tests, you get your poll taxes, all sorts of things that provided real barriers to voting. And so under Section 5, which is no longer, you would have to, for years, they would have to run their changes in voting law and maps past a three-judge panel, federal judge panel for oversight. And a lot of them got stricken down. But about 10 years ago, led by Chief Justice Roberts, they got rid of Section 5 and said, well, it had a timer on it, and we elected Barack Obama twice, so I guess we don't have racism in our country any longer. I mean, that's my interpretation. And they got rid of Section 5, leaving Section 2 standing, which we've always used to protect 14th Amendment and 15th Amendment rights to voting, both actual voting, so that your vote counts and that you can vote, and then your maps that are used for congressional seats and state seats and all sorts of things. But Section 2 is on life support, and now the Supreme Court has called it up for oral argument on the 15th of October. We're going to talk about that on a Louisiana case. And they could have killed it, but they seem to be interested perhaps in having the briefing around whether same-sex marriage, which passed 5-4 as a constitutional right, 10 years ago or whatever it was, whether that's going to remain the law or they're going to rip it out of the Constitution. We'll go over the math of some of the people that still exist from 10 years ago. And then I'll give you some commentary of Robbie Kaplan, who is not only E. Jean Carroll's lawyer, but also argued the case that preceded, and it was a direct lineal predecessor of the same-sex marriage case, the Windsor case. Same-sex marriage case, we call it the Obergefell case, but this Windsor case was argued by Robbie Kaplan, and I thought she'd be a great person to talk to. I have her on an interview that's going on Legal AF tomorrow. We can talk a little bit about that. And then you caught something great with Scott Bessent, Treasury Secretary, made a comment on Fox Business about the tariffs that are, they are in the courts right now as to whether they are lawful or not under emergency powers that Trump has granted to himself. And he made an interesting comment that you and I want to kick around. Mm-hmm. And then finally, we got a ruling related to, was it Mississippi and their social media law? Yeah, a lot of states are struggling with having children on social media. Not the stuff that, like the toy unboxing channels, where the 9-year-old shows other 9-year-olds about the new toy. It's more like places where people can meet, like sexual predators can exploit and be a predator on a child, that kind of thing. So Mississippi passed a law, and it was challenged by Net
Choice.
Net Choice, the netizens. They always bring cases about First Amendment freedom of expression. You did a good report about the pornography one. And this one got up to the Supreme Court And at least for now, it had a very interesting ruling with a concurrence by Kavanaugh
Mhm.
that I think our audience will find interesting. So welcome to Unprecedented. Hi, Dina.
Well, this is why we haven't done a preview show, because it keeps happening.
Yeah,
So many new, really important things to discuss. One day
that,
we'll get to the preview.
that should be our opening for every show. It's happening. Every show. All right. Why don't you kick it off with the Voting Rights Act? It's a
Yeah.
Louisiana case. It involves Mike Johnson, the Speaker of the House. It
Oh yeah.
involves, a state where a third of the state is black, but only 1/7 of the state had a black district
Hmm.
of the congressional maps. And now we're back up again. I thought we'd already considered this case once before, and there's arguments now, an interesting lineup of people on this case, as all they want to do is add one more black district to the state.
Seriously.
It's not like they want to make the state majority, but they just want 2 out of 7. Can we just
Yeah.
have 2 out of 7? And why don't you talk about what's up at the Supreme Court and how they're going to use it on Voting Rights Act Section 2?
I mean, it's called equal rights. That's all the black voters there want is equal rights. They want their vote to count as much as their white neighbor. But people like Justice Kavanaugh think, there should be an endpoint to this kind of thing, like as if we're in some sort of post-racial, post-privacy, post-whatever society. But either way, we talked a lot about this last week, but your point to Mike Johnson's state of Louisiana, tried to argue that they weren't doing the maps based on race, but they were trying to save Mike Johnson's seat. So that's kind of the funny aside there about Mike Johnson. But the 5 alarm fire update today is that they scheduled this for October 15th. We did not have a date for scheduling. The last briefing was due, as I reported last week, October 3rd. So they have scheduled that hearing like as quickly as they could after that October 3rd. I mean, that's fast reading for these Supreme Court justices. And the scary
They
part—
move fast when they want to.
Oh, yeah, they do. Oh, yeah, they do. So the scary part about that is because I was hoping that they wouldn't be able to do a decision in time to affect this 2026 midterms. But with an October 15th hearing, and Justice Thomas already has a draft opinion. I mean, right, Popok? He has had that sitting on his shelf for the past 30 decades.
What's it say? 30 years he's had a draft.
Exactly. So this is disturbing because they very well might issue a decision in time for the Voting Rights Act Section 2 to be stripped and be like a complete free for all, completely diluting people's right to vote in time for this midterm.
Well, you're in trouble because the geek lawyers that we are, you look at how the question has been framed and the question is presented by the Supreme Court and what they want briefing on. And that often is just dripping with where they are and what their thought is. And the question presented that they want briefed is the intentional creation of a majority district in in Louisiana, a violation of the 14th and 15th Amendment. I'm like, okay. So when I had Paul Blumenthal on, and it's up right now on Legal AF, and he just wrote an amazing piece. I don't think anybody's written more about the Voting Rights Act, and he's not a lawyer; he's just an amazing, intrepid journalist, than Paul Blumenthal. And he had a great article about it's on life support. I mean, if they strip it, his comment about the framing that he and I talked about was how upside down world that we are living in. That the reason for the Voting Rights Act was to enforce the 14th and 15th Amendment and give people and make sure that they have the right to vote. Now it's being argued that the Voting Rights Act violates the 14th Amendment, the thing it was created to help protect the rights of voters, because it's using race in some way that they don't like. And the other thing, Paul, that I talked about, and you and I want to hear your opinion, is why is there a shelf life on the Voting Rights Act? It's not in the congressional language. It doesn't say it's sundowns after. As soon as there's a kumbaya moment and we elect a black president twice, we can take it off the books. It doesn't say that. It doesn't say anything. Why is the Voting Rights Act being sundown by the Republicans. Like, Clarence Thomas wrote in his opinion, related to it, it can't go on forever. Why can't it? Why can't it until we don't have this problem? And as long as we have the problem, it should stay on the books. But you see where they are. Kavanaugh was so focused on because this case is coming up for a second round. They let the map sit around for now, but they said we'll come back to it at another time. Now it's back up, and now Kavanaugh, when the last time around, he was like really focused because there was an oral argument about the time. Doesn't this time out eventually? No, it doesn't time out eventually. Why would it?
Yeah. I mean, you would only think that in this like white supremacist point of view, that you are somehow doing a favor to people, and that favor has limits. But if you are believing that this is enshrining and protecting their constitutional right, there would be no end game.
Absolutely.
Point. But that's the viewpoint. They did us a favor. And
well, I think you're right on. That's a very good way to put that. And then in my interview with Paul, he made another point. He said, if the Voting Rights Act goes out the window with this case, Section 2, which Roberts looks like he's poised to do it, Kavanaugh looks like he's poised to do it, Thomas, Gorsuch, I mean, it looks like they have the votes for that. If that happens, there's 11 seats around the country on maps that were supported by the Voting Rights Act Section 2 that could be at risk. I mean, could you imagine if they were able to do this before the midterms? So you got the 5 seats in Texas that they're still working on, 11 more. That's 26 seats into the column of Donald Trump and MAGA, and we haven't even run the election yet.
And here's the thing, and just to briefly talk about, because I know we have other topics, we mentioned this before, the Supreme Court knows their power comes from the people. This is the time to share this video, talk to your friends, make this a topic. When Mitch McConnell stole those 2 seats, when he didn't give it to Merrick Garland, when he put in Amy Coney Barrett, I wanted people to like be out in the streets and protest. Because as a lawyer, like I knew the implications of that, but it was kind of crickets. For a very long time, the public has kind of accepted the Supreme Court as somehow being like untouchable or not as important to their daily lives. If we make some noise around this, they may not go as far as they want to go. And I think Governor Newsom, I call on Newsom too, bring this into your fight. Start calling this out. If this gets passed, California shouldn't just match the 5. Like other blue states shouldn't just match the 5. Like let the Supreme Court know if this comes off, then those white voters, they may have their vote diluted in certain blue states too. And how is that going to feel? Like realize that everyone is going to take the gloves off. And I think that's the only way to restrain them.
Absolutely. Absolutely. I mean, there is yeah. I mean, if they are able to pull this off, the goose is cooked when it comes to having a majority districts. And look at the map. This is so weird anyway at this case. The NAACP is on the same side of Louisiana. They're both arguing for this district. And it's the non-black voters and maybe Cajuns in Louisiana who are going to make the law here about Voting Rights Act. It's just mind-boggling. But let's switch gears for a minute and go to same-sex marriage. So Kim Davis.
Mm-hmm.
Oh, I say the name and I have to go take a shower. Kim Davis, who was a clerk of where was she a clerk in
Kentucky?
In Kentucky,
mm-hmm.
And said, "Oh, I'm a Christian lady, and I'm not going to issue a marriage license to same-sex people." She was the only clerk. The only place to get a license was getting it from her. She just denied the licenses, even though she couldn't do that under same-sex marriage law, and she got sued and put in jail. She got sued and she got put in jail, and she got I think she owes a $300,000 judgment to the couple and others. And so her lawyers, run by some MAGA right-wing entity, took a appeal and ultimately up to the United States Supreme Court. And in their third argument, they want to argue that Obergefell, which is the law from 10 years ago establishing a right under equal protection and due process for a same-sex couple to be married.
Yeah.
And it stood on the shoulders of an earlier case that was argued by Robbie Kaplan when big law firms were able to do pro bono cases. And she worked at Paul Weiss, the firm that was the first to fold under Donald Trump's thumb or under his heel. She argued successfully in a case called Windsor about a woman who married and when her wife died, left her money in an estate. And the IRS came and said, give us $300,000, please, because we don't recognize your marriage under the Defense of Marriage Act. And Robbie successfully argued that that was an equal protection and due process violation, treating two couples, one heterosexual, one gay, differently. And it was a 5-4 decision written by Justice Kennedy. Fast forward 2 years later, we come to Obergefell about fundamentally whether there is a right in the Constitution to gay couples to be married. And it was also written by Kennedy, and it was also 5-4. And it was, yes, it's enshrined in the Constitution. Talk about what's going to what's happening now.
Yeah, so they found there was a liberty right in the 14th, 15th Amendment. And the interesting thing about Kim Davis is this case that's up in front of the Supreme Court has to do with her losing her lawsuit to that couple because she's arguing that she shouldn't be liable because she, as a she had a freedom of religion right to deny their exercise. To deny their marriage license, and also that the Supreme Court case enshrining same-sex marriage should be overturned. So this is a long, process. Let's say this Kim Davis. This happened way back in 2015. This is a long process. This case that still has to do with it. The interesting thing, and the reason why this case, I think, got a lot of attention, because obviously we don't know yet if the Supreme Court is actually taking this case. They will decide in their September 26th conference whether or not to take this case. If they take the case, this is a big concern because it means that they may overturn it. We're not at that point yet, but the reason why it made so much attention is because when Kim Davis asked the Supreme Court to take the case, the couple who was on the other side declined to respond to the Supreme Court, like at all. They didn't make any arguments for whether or not the Supreme Court should take the case or not. And so the Supreme Court could have just denied the cert outright. They do that they get a lot, thousands and thousands of requests. They could have just denied it. But instead of denying it, they asked this couple to file a brief as to whether or not the Supreme Court to take the case. So that is showed that there was at least one justice. Interestingly, it was either Justice Alito or Justice Gorsuch that asked the couple to file the brief because they're the only ones not involved in the cert pool. Most likely it was Alito because Alito and Thomas have articulated many times how they want the case to be overturned. Justice Gorsuch has been better on this issue, at least with the transgender issue. He was better on. He helped with the workplace, saying that discrimination applied to transgender as well.
It's hard to tell where Gorsuch. I didn't even interrupt you. Go ahead.
No, but it's true. I mean, when I say better, it's fine lines here. But Alito most likely was the one to do it. But the fact that they didn't just deny it outright showed it went past, let's say, the preliminary step.
Yeah.
But we are still a ways from whether or not they're going to take the case. Also, I just wanted to point out really quickly, for those of you who are paying attention, if you remember, after Dobbs happened, Congress passed the act in 2022 under Biden, trying to protect same-sex marriage. The name of that act was the Respect for Marriage Act. So if the Supreme Court overturns their case, what it means is that there will still be states who could outlaw same-sex marriage, but they have to recognize each other's states. In case you're wondering, how does that congressional act fit in? That's how it would fit in.
So Robbie's view, and it'll be up today with us probably in about 2 or 3 hours here on Saturday. Robbie's view is that they could, if you lined up the votes from who voted against, because in the 5-4, Roberts Alito,
Mhm.
and Thomas voted against same-sex marriage as a constitutional principle, constitutional right, and they did the same thing in Robbie's case. And I said, well, isn't that a fait accompli then? She said, with Gorsuch and Amy Coney Barrett, she said even she thinks Roberts won't go there because he doesn't want, from a political standpoint, he doesn't want the ramifications on his watch of what it means to declare people who are married no longer married, who have children, who like the repercussions would stop him from undoing that which has been done for 10 years, like almost like a reliance principle. People have been relying on same-sex marriage. And the polls say that every year, more people in America are okay with same-sex marriage, not less. Even much more than even 10 years ago when the case was. It's more accepted. It's more, kids today don't care about two dads, two moms, two whatevers. They don't. I mean, they're much more accepting and tolerant than our generation is because they grew up with it. So that's her theory. They could do it. If you look at the numbers, they should do it. And but that Roberts won't do it. But then the question is, even without Roberts, are they going to get Amy Coney Barrett and Gorsuch to slide over there, and or Kavanaugh? Or even take the case. I mean, why take the case with Kim Davis carrying the water? She's so disgusting.
Mhm.
She's so disgusting.
Yeah.
But
and it's possible this isn't the case they want. She might not be the person that is going to do it. But I do think, like, to your point, the makeup is critical. I know Roberts cares about the legacy, but I don't know. Everybody was relying on Dobbs. Public opinion for pro-choice is massive, and it didn't care.
Yeah.
Robbie's
view, who you'll see later today, and she herself is gay. Robbie's view is, but like taking away gay marriage is a bridge too far, even for Roberts. But we'll see. I mean, if she, we'll see. But how long something is around and whether that leads the Supreme Court to accept or change things also came up in the tariff issue as we transition to our final topic, or one of our two final topics, because you caught something with Scott Bessent about the hundreds of billions of dollars of tariff collections that have been going on while the courts grapple with whether Donald Trump exceeded his authority, because there's no emergency, a creeping trade deficit over 10 years, including on Donald Trump's own watch the first time, is not the equivalent of, we got an emergency, we got trade deficit emergency, to give the president the power of the tariff. Congress has the power of the tariff by constitutional right. But and as we saw from the argument that was made to the entire en banc panel, the entire panel of the DC Federal Court of Appeals, that there's nowhere in the Emergency Powers Act a reference to the power to tariff, sanction, not tariff. And so you caught something Bessent said. In fact, why don't we play the clip that you caught, and then you can comment on it. So let's see Scott Bessent on Fox News about how much money they've collected and his view of what that would do to a case.
But I tell you, Larry, the amount of money that's coming in here, I think the more deals we've done, the more money coming in, it gets harder and harder for SCOTUS to rule against this.
How much you got cooking on that, the amount of money? Ballpark. Both private direct investment and these government investments.
Well, just on the tariff income, I've been saying $300 billion, but I think we're going to have to substantially revise that up. So well in excess, 1% of GDP. And then with the new investments, they're the sovereign investments that we talked about. But then in terms of the committed investment by private industry, we're well over 10 trillion.
I love 10 trillion. It's an unbelievable number, unbelievable story.
All right, take it from there. What do you think?
Well, it's just the level of corruption. That was what was so shocking to the clip for me, because he's not even trying to make some sort of legal argument, like as if, we should have this authority because the president's executive power, da, 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 da. It's like, oh no, the amount of money is going to stop the Supreme Court from ruling against us. That kind of blatant corruption, because the Supreme Court isn't supposed to care about whether or not something is going to be, it's like you shouldn't be able to violate the Constitution because that person is going to make money or not make money. Like, that's literally not supposed to be part of the equation at all. So it's either he knows the Heritage Foundation has put in a bunch of justices that, care about corporate interests above all else, and he's used to talking like that behind closed doors with them or others. Or, this just shows like how corrupt the administration is, if they are just speaking. They don't even realize how they are speaking, right, on this national TV to somehow act as if, we're going to decide the law of the land. We're going to decide that the Congress no longer has this power solely because of the amount of tariffs that have come in.
Yeah, and Bessent's now sitting around with Howard Lutnick and Marco Rubio and Steve Witkoff, in Alaska, negotiating some Ukraine resolution under a banner of pursuing peace. There's a missing piece. It should have said missing piece, and that is Zelensky and Ukraine. How do you this? What are we back in the 1940s? Is this like Yalta, where Stalin, Roosevelt, and Winston Churchill divided up Europe and the Soviet Union, all those areas? Is that what we're doing now? We just leave out the country, and now we're going to reward Putin because then Donald Trump can claim art of the deal, reward him for. The reality is it's a 2-year-old war, and Putin has not been able to crush the Ukrainians. They have fought him, even though they're like 1/10 the size. They have fought him to a standstill. Sure, with a lot of our military might, but they fought him to a standstill. And now we're going to give him territory that he could not obtain militarily as a reward for his bad behavior. I just don't. I mean, it's just the immorality of this administration just knows no boundaries, and we could start every topic with that observation. And Bessent's there, what is he was investing money for George Soros. I'm going to be doing a hot take soon. He's not even in compliance with his ethics. He hasn't even sold off all of his. He just got the ethics watchdog just said Scott Bessent is violating ethics laws because he hasn't sold off all of his stock. Is this the guy that should be commenting about world affairs and tariffs in the Supreme Court? Name me one case that you either argued at the United States Supreme Court, involved you at the United States Supreme Court, and yet you think everybody's for sale. It's all the almighty buck.
Absolutely. Right. Exactly. They think everybody is for sale.
Yeah.
Completely transactional.
Let's go to, let's just touch quickly on Mississippi, because we had an odd occurrence because Mississippi passed a law. You can talk more about it in detail about certain types of social media platforms that minors under 18 are not going to be able to have access to. Also setting up fine structures for other types of vendors and platforms to age verify. It's not a bad thing. And that law was challenged by, open internet advocates as a First Amendment violation, much the way they did about the pornography age verification thing. And the Supreme Court's not ready to hear the argument, the substance of the argument, but they're also not ready to block the law either. And there was a very interesting concurrence by Kavanaugh. Why don't you catch everybody else up about why this is not the last we may hear about this Mississippi law?
Yeah, so it's interesting. Basically, as you said, they outlawed under 18 access to certain sites like Facebook, Instagram, X. They had, they said they were trying to stop like sex trafficking, bullying, cyberbullying. I think the law was named after a teenager who committed suicide after some sort of like sex cyberbullying. And so the net choice on behalf of these social media companies are suing, and the Supreme Court decided to leave that law in place. The companies will be fined $10,000 per violation. They decided to leave the law in place, while it's, as we've talked about, like why they decide whether or not the law is legal or not. They're not going to pause the law. And Kavanaugh was the only one who spoke out. As we know, the shadow docket, they don't they don't explain why they take or don't take a case. But Kavanaugh clearly said that he thought that the underlying law was probably unconstitutional, but that these companies hadn't shown that there would be any harm. And the interesting thing is, I guess the Net Choice lawyer couldn't really point to any specific harm. It said that they had not identified anyone with a complaint about accessing any platform, one instance of a platform censoring speech, or any platform that has shut down or had any difficulty complying with it. So because they really couldn't show that they were going to be harmed to the extent that this needed to be paused, and Kavanaugh said he believed the state interest for having the law proceed. So it's interesting. I mean, social media, being parents, I know your daughter's still really young, but that's kind of like something that is, it's like the cat is out of the bag, right? Social media has great things. A lot of kids connect on social media, but it's got a lot of harmful things, a lot of misinformation, talking about a completely different avenue. And these laws, several states have tried to have laws in place like this of limiting ages. Teenagers tend to get around a lot of those age restrictions as well. So, we'll see. I think this is still, but so right now in Mississippi, that law is still in place. And if you're under 18, you cannot access those sites, theoretically.
Yeah, kids do know a way around it. All sorts of burner pages and burner profiles and phony profiles. They'll use a friend that's 18 and, but and it sounds like even Kavanaugh thinks the law may not pass muster, but they're also not going to do anything about it right now. It's just so maddening.
Yeah, it is, right. Because if it is unconstitutional, like in the meantime, it might be several years while this law is in place.
And the problem is it comes up through these emergency applications and, there's no institutional focus. They're all traveling. They're all away. They're not together. They're not chewing the fat in the hallway about these issues. They're all in different places. And then you get these no word rulings. And no words, the only way I knew anything was going on was Kavanaugh.
Well, it was interesting too, because he just spoke out about the shadow docket and kind of tried to justify why they don't give an explanation. He was like, we don't want to give too much detail because we haven't seen the full case. And what if we give them the wrong impression? Yeah. And so then, like just 2 weeks later, he's the only one who speaks out and says it's unconstitutional.
I don't think you're constitutional, right? I don't want to give you any guidance. Yeah. Yeah, because what you're pointing out is that they are obscenely inconsistent on purpose. That's why we have difficulty. Our audience is like, "Oh, I thought based on something else you told us that the case would go this way." Well, because they make it up as they go along and they change the tools that they use. When it's reverse engineering, they have a result they want to obtain, and then they'll grab at or discard constitutional doctrines, interpretive tools in order to reach that thing. And if they look like, like in the election law area, if it looks like they're gonna have to make a decision they don't like, the Purcell doctrine, we're too close to the election, we can't interfere, it's a political question. Except, or no, we couldn't possibly overturn that. That's a major question. That has to be decided by Congress. Congress has to speak here, not us, except on Voting Rights Act. Voting Rights Act and taking away the right to vote and disenfranchising and making them not have power. That's not a major question for the Congress who passed the Voting Rights Act. You get to interpret the Voting Rights Act out of existence. What happened to the major questions doctrine?
Oh, or what about states' rights? That's my favorite. Oh, yeah,
we're
all about states' rights. And
we're not.
The Supreme Court going to really step in and protect these cities from having Trump go in and send military?
So the best we can do is call bullshit on the Supreme Court. I thought you were originalists. I thought you were textualists. I thought the words mattered. And And then they come out and they go, oh, you're right. In fact, the words are so important. When it comes to gun control, we're going to go back to 1870 to determine whether a certain restriction would have been able to pass muster or not. We're like, what? Now the dead hand of history is telling me whether, you can have a bazooka in your house to defend yourself. So it's all, they want to act, especially Roberts. He's always got this. What's the word? He's just so unctuous. It just has this air about him of like you said, it's a privilege for you to meet me and talk to me. We're infallible, and whatever we say the law is, that is the law. But that's not how it works. And their reputation is in tatters, and people are, starting to ask real questions like, why do we have to listen to them? Like, why? Who made them? Who died and made them boss? I mean, like that. And they know they don't have an army. They don't even have a president that is in favor of the rule of law. So, like, if we all just said, you know what? No, we don't agree that same-sex marriage should be ripped out of the Constitution. No, what would they do? We just said no. Like, we're good for you. That's your opinion, literally.
Yeah,
but we don't agree.
Well, this is why I'm so grateful we do this. I know we're wrapping it up, but let's say that this is the point, because it's easier for them to do it if the public is quiet, because that's complacency. And the public is complacent if they don't know, or they think somehow it is like a done deal, right? But it's never a done deal, because like you said, they get to pick even the cases. So they get to pick the ones that are best suited to be reversed or not be reversed. And Roberts saved Obamacare because he gave Bush the election, and he knew he couldn't do like bad ruling after bad ruling after bad ruling. There is a limit. And the more we are talking about it and making noise, we make it more difficult for them to do all the bad rulings. It's a long game. The Supreme Court is a long game. We have to, we're not going to win overnight, but if we slow them down, like this marriage equality, they don't take it this time, then you don't know. We might have a change of a makeup. We might have change of public opinion. We have to slow them down. That might be our win at this point.
Yeah, absolutely. Well, I'm so glad that you're here with us and briefing our audience about things at the intersection of law and politics. Good news, Dina Dahl is going to be joining me regularly for Legal AF Substack Live. We're going to do one next. We're going to do one next week. Next week, Katie Fang's doing one regularly with me. We got Adam Parkmenko who's going to be joining me next week. Brett Meisalis has promised that he's going to join me. Michael Cohen says he wants to come on. I've done a couple on my own. Now that I figured out how to use the Substack Live button, now I'm doing them like every hour, every day.
Oh, awesome.
And I really do appreciate you all being here for Unprecedented here on Legal AF. And while you're here, hit that free subscribe button. Help us continue to grow this channel. Follow everything that Dina Dahl does, wherever she does it. Just find her. You have to find her, including on Legal AF Substack. And then we've got a Legal AF Substack where we put, go on there now. It's just a treasure trove. It's a cornucopia of things you might be interested in. It's videos and these videos and ad-free versions of the Legal AF podcast and the Intersection podcast that I do. And you'll see this and clips from this and articles and the filings and the orders that come out of courts all in one place under one roof. Legal AF Substack. Take a minute and go over there. And if you really want to help us keep the lights on, you can become a paid member of Legal AF Substack as well. So until our next report, Dina Dahl and Michael Popok, shout out Legal AFers and Midas Mighty. Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.